administrator with the Nevada Equal Rights Commission, and my colleague here is Stacy Pratt with the ACLU. We're going to talk about the new laws that took effect on October 1st and how we're interpreting them and what your protections are. From my perspective, I'm here because I think it's very, very important that you understand your rights and the rights of others. And I'm out in the community and talking to employers to communicate that as much as possible so that they know how to act in the workplace, so that your coworkers know how to act, so that you know how to act in the workplace. And also, as we'll talk about, that extends to public accommodation and housing protection as well. So Stacy and I are going to kind of go back and forth a little bit. We haven't presented together before. Stacy's just arrived here to Las Vegas 2 weeks now, so I don't know, welcome her to Las Vegas. Thank you for coming and for the work you do with ACLU. So the new laws took effect October 1st of this year. You may or may not know they added protections, and the one that we're going to be focusing on today is the protection for gender identity or expression. And that's in the workplace, in public accommodation, and in housing. There were also some other protections added at the same time that I'd like you to be aware of, but we're not going to be focusing our talk today on that. In housing, sexual orientation was added finally as a protection for housing discrimination. And in public accommodation, sex was also added as a protected category, with a few caveats. But anyway, so I wanted to talk about gender identity or expression and what it means in the law. I'm sure that everyone kind of has an idea of what it means to them or what they think it means. Sometimes the law is going to interpret it a little bit differently. And just real quickly, I want to read to you the way it was written into Nevada state law. It says gender identity or expression means a gender-related identity, appearance, expression, or behavior of a person, regardless of that person's assigned sex at birth. So I read that so you can see how broadly it's defined, or you could say it's not defined at all, pretty much. From our perspective, that makes it all-encompassing. That's good. It doesn't limit to a certain type of gender identity, a certain type of expression. From our perspective, and that's, from the Equal Rights Commission as a state agency that will handle these kinds of cases, we think that it also doesn't necessarily limit to male or female. There could be an identity of neither or both. There could be an identity or expression of being androgynous. And from our perspective, that's included under this law as well, as far as being protected under discrimination law. What I mean by that as well, when I say that the law protects those categories, I'm talking about from discrimination in employment, housing, or public accommodation, and discrimination in the form of harassment, which is kind of a feeling. It involves name calling or epithets or slurs, being excluded, being treated disparately, maybe more harshly, ridiculed, that kind of thing. In the workplace, that also extends to housing and public accommodation, that harassment protection. I'm also talking about having adverse actions taken in the workplace because of your gender identity or expression or any of the other categories protected under the law. And adverse actions meaning not being hired, not being promoted, being disciplined, being fired, anything in between, including the terms and conditions of your employment. In other words, altering how you do your job, giving you a duty that someone in your position normally wouldn't have, that kind of disparate treatment. So the law now protects against that kind of disparate treatment in the workplace, public accommodation, and housing. And that's why we find this so important and why educating the public is so important. Because your coworkers as well need to know that this protection is in place so that they're not treading on your rights and vice versa. So we would say gender identity is an internal sense of your gender. And as I said, typically it's going to be male or female, but it's not necessarily limited to that. Gender expression, as you might expect, is your outward appearance or behaviors or mannerisms. As Jane would say, it's a way of putting yourself in the world as far as your gender. It could include clothing, hairstyle, a way of talking, a way of moving, a way of acting. Those are forms of expression, and the protection is if you're expressing your gender in one or more of those kinds of areas. So the point of the law is that you shouldn't be judged in the workplace because of how you're dressing, acting, talking, speaking, or whether you feel that you're male, female, or some other identity. You should be judged on your merits, on your skills, your ability, your performance as far as employment. And I'll focus on employment because it's the most of what my agency sees. We're going to talk about some of the other things because certainly public accommodation, there are issues that are going to come up. But I focus a little bit more on employment. So you see this has really broad coverage. As far as gender expression, if you look at the way it is in the law, it says gender identity or expression. That or, as opposed to and, is very important because basically it gives you two protections. It's almost like having two separate categories, and it means that they can be mutually exclusive. So that includes then if your expression is, let's say you gender identify as male, but perhaps you like to express yourself as female or in female clothing on occasion. The law would say that's protected. That expression is protected because it's that broad. So, is proof of your gender identity or expression required? Absolutely not. If an employer or a place of public accommodation, like a restaurant, a bar, a gym especially, if they ask you, prove it, show me your driver's license with the gender marker on it. Do not have to. The law protects against that. You do not have to provide proof. And Stacy's going to talk a little bit more about those areas of the law and what she found in researching other jurisdictions that have this coverage. It's new to Nevada, but it's not new nationwide. There are, I don't know what you found, the last statistics I had as of 2009, there were 13 states, so Nevada's 14, 109 cities, and Washington, D.C. already have this type of protection. So it's not new in the country, it's new to Nevada. And we're looking to those other jurisdictions as far as how to react to the law and where we think the protections are. And as you can see, very, very broadly protected. Do you have to be living full-time as the gender that you identify as? The answer is no. You don't. And especially if you're in a period of transition, perhaps you're not living as a specific gender at every moment of every day. So the law doesn't require that as well. Does the law require consistent expression? And this is something we'll banter a little bit about with Stacy. Do you want to talk about that section now?
Sure. One of the things that we wanted to do, this is new to Nevada. So when you have a new piece of legislation that comes into play, it's very helpful to look to other jurisdictions to see how have they interpreted it, how has it worked, what hasn't worked. And one of the things I can hand out here is a number of jurisdictions have looked at the issues of gender identity and gender expression and defined them in their own way. Most of them are very consistent with what you've heard so far today, but some of them add additional elements. And this was something we actually kind of had a discussion on. Just let me know if I give you enough time to not one of the questions that we were looking at is whether or not, for example, does the gender identity or expression need to be sincerely held? Does it need to be something that's part of a person's core identity and not being asserted for an improper purpose? What level of proof is required? Should proof be required? And we were very clear that proof should never be required. But at the same time, is there an issue of sincerity? Is there an issue of consistency? And that was something we had discussed prior to this. Connecticut does require those elements. And I think it relates to situations where there was a concern. Did you want to relate that example of the employee who kind of...
Yeah, I've been going out with Jane Heenan, who you all probably know, who's kind of organized this event. We've been doing presentations to employers about discrimination in general and especially about the new law. So just this week, as we were doing a presentation, one of the employees stood up and he said, I have a young daughter and I want to take her to the women's restroom because it's cleaner and nicer and I feel safer going in there with her. And he said, of course, everybody would have a fit if I went in there. So he said, so what you're telling me is if I say I gender identify as female, that I can go into that restroom now and bring my daughter. And I was speechless for a moment and not knowing how to respond. And I'll say, we'll kind of give you our opinion right now, but it's not yet been determined. It may have to require some kind of challenge in court to interpret the law because the law is so broad. So the idea of a sincerely held belief is not new. It's used with religious coverage under discrimination law. If someone has a religious belief, the law says it has to be sincerely held. And it also says that the employer can't challenge that belief. So it's kind of a similar set of circumstances as far as how religion is handled in discrimination law. So my opinion, and I don't know if that's your take either, is that's the direction I would like to go with it.
And actually, I wanted to raise it with the community and say, are there thoughts within the community about what's the best method? I mean, I certainly understand the desire to make sure no one's out there mocking the protections, but at the same time, I don't want to enter a situation where folks even feel on any level that they have to prove who they are. That's totally inappropriate. So I don't know if folks within the community have feelings, or if there are others who might say, wow, I really want to avoid that kind of language. I think this is going to be so rare that anyone who did that, they're just foolish people out there. Or you know what I mean? Like how people themselves thought about it. And I just think part of this conversation is we're trying to figure out some methodologies to make this an effective protection. And in doing that, sometimes you have to reference what's going on in other circumstances. Is there anyone here who has thoughts or would like to share? Not enough coffee yet. That's always my problem.
I would like to share a thought, if I may. Like, for example, public restroom, it's a scenario you're talking about. It's not appropriate to be, have to prove your gender.
Exactly.
Right.
Exactly.
But is it necessarily appropriate to be accused of the opposite gender and not have repercussion?
And that would be harassment, right?
Right.
I mean, and that's what other jurisdictions have found. I want to go into depth on the public accommodations piece and the whole restroom issue. I think that's an important one that people tend to face, and that's a big part of the case scenario we're going to discuss. I didn't know, are you kind of ready for that transition? Or?
I got about 5 more minutes worth of stuff.
If you don't mind holding for just 1 minute.
Let's come back to it either way. What I wanted to say about the law, so that you know if any of this kind of discrimination is occurring in the workplace, in public accommodation, or in housing, if you're being harassed, or decisions are being made about your employment based on this new protected category. For employment, you have 300 days from the last date of harm to file with my office. The law, there's been some case law that's interpreted the way the law is written that says that you have to go through an administrative process first before going to court for employment. The law has been interpreted. So what that means is you have to file with my agency to allow for the administrative purpose, and then you can go to court. So you don't want to go straight to court because you could get booted out for not having gone the proper route. And that timeliness issue is also in the law. So if it's 301 days or anything longer, it's not jurisdictional. We couldn't take it. So know that you have that limitation for employment. It's 300 days for public accommodation as well. You go into a restaurant, they refuse to serve you, or they don't let you use the bathroom of your choice. You have 300 days to file a complaint with my office. That is protected, and we would investigate that. Housing, you have 1 year. And by housing discrimination, we're talking about either renting, leasing, or buying a dwelling. And the stipulation is there have to be 3 or more units, or an owner has to own 3 or more houses, apartments, or duplex units. So if it's a single person that owns a second house that rents it out, that protection is not there in the law. It has to be a minimum of 3. But if you think you're not being allowed to rent a place or buy a place or even be shown a place that you're interested in because of your gender identity or expression, you're protected under the law from that. You are also protected in housing from a form of harassment, from the terms and conditions of you dwelling in that place. So if you're being harassed for your gender identity or expression or any of the other areas that are protected under the law in your housing, in the terms of your lease, well, let's say the property manager says, you know, you've got to come in the back door because we don't want folks to see you. That's absolutely something that could be filed at my office. So it's mostly, you know, renting or purchasing and associated circumstances, but it also includes harassment and the terms and conditions of your lease or your agreement. In public accommodation, it's equal access, equal enjoyment of that place of public accommodation. And it's a place open to the public. So a lot of the places you might think of, you know, restaurant and bars, gyms, schools, as far as public areas of the schools, that gets a little tricky. But any place that's open to the public, if you're treated disparately or not allowed equal enjoyment, you could file a complaint with my office. The last area I want to talk about specifically has to do with grooming and dress code standards, because that's come up. It was another kind of point of contention, and they actually wrote something into the law, the state law, addressing that. This is in the employment section, and it says, it is not an unlawful employment practice for an employer to require employees to adhere to reasonable workplace appearance, grooming, and dress standards, so long as such requirements are not precluded by law, except that an employer shall allow an employee to appear, groom, and dress consistent with the employee's gender identity or expression. So to me, 2 really important things in there. One is they can ask you to adhere to a reasonable, that's to me a key word, reasonable workplace appearance, grooming, and dress code standard. And the other part that's important is it says that you should apply the dress code standard that's consistent with your gender identity or your gender expression. So if you're gender identifying as female and there are 2 uniforms, one for males, one for females, you wear the female uniform. You're adhering to the dress code standard and you're able to use the one that's consistent with your gender identity or expression. Okay. Thank you very much. I'm going to pass it over to Stacy.
Well, and thank you for that great overview. Okay, now we have kind of the big picture, what the protections are. But this is how my brain thinks. I need something concrete. What is real? How does this translate into a person's individual experience? And this is the reason I brought up the case scenario. Does everybody have a copy of the case scenario? Anybody missing? Let me. And I also need someone who likes to read. Is there anyone who is outgoing and likes to hear the voice?
I have my reading glasses.
Did I get everybody?
Yeah, I know.
Did you read it?
Do you need me to hold it for you?
Yeah, I mean, focused perfectly.
I know.
All right, what? Should I
read
read?
the paragraph? Would you mind? This is a
Certainly.
case scenario to show people what this law really means in practice, okay? And this is a real case. Not in this jurisdiction, but in a jurisdiction very close to ours in 2007. So this all happened, okay?
So I'm starting with Crystal.
Yes, if you could. Thank you.
Crystal is an employee for the State Transit Authority. She was born as a biological male and given the name Michael. She, however, identifies herself as a woman and has lived and dressed as a woman outside of work and used the name Crystal. She has begun taking female hormones to prepare for sex reassignment surgery in the future. While she has begun to transition from male to female by taking female hormones, she has not yet completed the sex reassignment surgery. She described herself as a preoperative transgendered individual. Nearly 4 years after she had begun taking female hormones, she applied for a position as a bus operator. She was hired and trained. I get to keep reading? Okay.
Oh, yeah, you're doing great.
Okay. During her training period, she presented herself as a man and used male restrooms. Soon thereafter, she explained to her supervisors that she was a transsexual and would dress as a woman. The human resources manager met with her and asked her where she was in the sex change process and whether she still had male genitalia. Crystal was forced to explain she still had male genitalia because she did not have the money to complete the sex change operation. The human resources manager expressed concern regarding Crystal's use of public restrooms along the route. Crystal used female restrooms in line with her gender identity. The nature of the transit routes Crystal worked required her to use public restrooms.
Great, very nice, thank you. So the first question I would have to ask you is, what do you think happened prior, say this is Nevada, prior to the enactment of the statutes we just heard about, what do you think the likely consequence for Crystal was? She get fired?
Yeah.
Did anyone say anything about maybe the harassment she went through? No, right? And that is actually the reality. Prior to having gender identity and gender expression laws, this is exactly what happened in Utah. This case happened in 2007 in Utah. And what the court found there was that, and I'll read this, unless someone else wants to volunteer, but that the Transit Authority discharged Crystal based solely on her intent to use women's public restrooms while wearing a UTA uniform, the uniform of the Transit Authority, despite the fact that she had male genitalia. UTA states it was concerned the use of women's public restrooms by a biological male could result in liability for UTA. This court, and this is the 10th Circuit now, agrees with the district court that such a motivation constitutes a legitimate, non-discriminatory reason for, and Crystal's name was SCC, termination. And they found that the Transit Authority's reason for termination was legitimate and non-discriminatory. And this case was brought under Title VII and Section 1983. So that's really troubling. That's a horrible result, right? I mean, and this is 2007. So the reason I put that on the table is I want us to think about, say this case were to happen in Nevada today. What do you think the likely consequence would be? What kind of opportunities would Crystal have to challenge what happened to her? Any thoughts?
Isn't Nevada a right to work state?
Well, that's part of the issue. Also part of the issue is, would this be considered discrimination in an employment context based on gender identity and expression? It would. And so she could file a complaint with NERC saying, I was discharged based on my gender identity. What else? What about the fact that she was asked specifically about the nature of her physiological change? What do you think of that? Inappropriate. Very inappropriate. And other jurisdictions that have looked at this issue, for example, the DC Office of Human Rights, in the District of Columbia, they've had gender identity and protections in place since 2006. So they've done this for a while, and some of the regulations they put together specifically describe situations like this. And I want to share that with you, just so you know, this is unlawful harassment. And it is inappropriate for any employer to ask questions such as, what is your individual body? What is the nature of your physical transition? Another area that is very important to recognize is on the use of pronouns. Say, for example, in this instance, Crystal came to her boss and said, I identify as female. I would prefer to be heard the term she and her. And the boss consistently said, I'm not going to say that. I'm going to call you he. I'm going to refer to you as male. That happens, right? I mean, it's a reality. That's also harassment. That's also inappropriate. The New York Commission on Human Rights, and they've had their law in place since 2002, has specifically said to avoid the appearance of discrimination, individuals should be addressed with names, titles, pronouns, and other terms appropriate to their gender identity. So the right thing to happen is for the company to say, how would you prefer to be addressed? And if the individual says she or he, those are the appropriate terms to use. It is inappropriate to say, are you pre-op, are you post-op? None of those things are of concern. They're very private, and they shouldn't be things on the table. So it's just important to recognize that there are protections now that used to not be in place. One of the other things that's really strange to me about this case is that it deals with public restrooms, right? This is an issue you raised earlier. How are restroom use to be determined? And as we've heard, it's based in other jurisdictions on your gender identity or expression. So essentially, if you have an internal sense of yourself as male or female, that is the restroom you are entitled to use. And that's true in a public setting, it's true in a public restroom, it's true in a restaurant, and you shouldn't be challenged. You should never have to provide ID that says, this is my gender identity. And you should, you raise the question of what if someone does? What if someone says to me, you're going to use the restroom as appropriate to your gender identity, and someone comes in is hateful and says, well, I don't believe you're X or Y gender. Show me your ID. That's harassment, and that's something that's actionable. You can complain to NERC, and also let us know at the ACLU. We want to know if people are being treated appropriately. We brought intakes, and we have our cards here. So if those things happen to you, we want to know, because it's important that the protections that are in place are adhered to, and that folks get their rights. And so that's important to know too, when you're looking at issues of public restrooms. Let's see. A number of states have looked at that issue: Colorado, Iowa, San Francisco, Washington, D.C., and they've all agreed that access is based on gender identity. And I think that's something helpful, and New York has said that it's discriminatory conduct to require to prove ID. And on public restrooms, as far as employers are concerned, some of the suggestions that are out there include, say you have an employer who has a single restroom, or maybe two, and one says men, one says female, then they should just put the word restroom on it, so it's gender neutral. And those are just kinds of accommodations people can make in order to protect people's rights and be respectful. I don't know if you have anything to add on the public restroom?
Just that the same thing extends in the workplace as far as restroom use. That if there are segregated restrooms, which there typically are, that whatever gender you identify with is the restroom that you're able to use. I didn't find any exception in the other jurisdictions about bathroom use, did you?
No.
No. So your gender identity is the restroom you are allowed by law to use in the workplace and in public places.
Right, and you can't be harassed for using that bathroom. That's important to know. On just some more minor technical stuff, name changes. Sometimes folks are in a position where they want to change the gender marker, for example, on their driver's license. And we have some of the forms here to do that. The DMV has a form on their website. It's very easy to fill out. You just need a doctor's signature, and you submit it to them. So it's really a streamlined process. We have the forms here, as well as we have our Know Your Rights cards for folks who care about the transgender community that walk you through this process. But the DMV is pretty amenable to this at this point in time. Another thing you can do, sometimes people say, what about my birth certificate? How do I go about changing my name on that or my gender identity? And what you can do is, first, you have to go through court. You have to put a petition together. We also have sample forms for that. This one is for Clark County. This is for Washoe County. And what you do basically is you fill this out, they walk you through the process, but if there's a challenge, let us know. You get a court order that changes your gender identity or your name or both, depending on what you're wanting. And then you can actually send that on to the Department of Vital Statistics. And for $40 and with a certified copy, they will reissue your birth certificate so that it reflects your current name and gender identity. So I know sometimes those are points of concern. Yes?
Does that work for other states too? For example, I was born in California.
That's a great question, and I would have to research California, but I think California tends to be very friendly to folks in the transgender community.
So I can basically use that same form and submit it to California?
Well, I think we'd have to find the form for the California jurisdiction, but if you want to, we can follow up on that and try to help you find that. If that's, yeah, I'd be happy to.
And you're at 6 in Gas?
We are at 6 in Rancho.
6 in Rancho.
Yeah. And then we have a website too, aclunv.org. that has, if you have complaints, if things are happening that even though the law's here, sometimes there's enactment and then there's compliance. And they don't always happen at the same time. So if you encounter those situations, please let us know. We have sample complaint forms, but you can always do it online as well. And I've got my cards here as well. If there are issues that, maybe you don't want to discuss now, but later you do, please do let us know.
Yeah, just one comment with Nevada. In
Sure.
California, which you discussed, I was originally born in Missouri, and having done some research, there's a different process you have to go through. So depending on where you're born, the best thing to do is go on the internet and research. If there's information online that says, if you're born in North Dakota, this is the process you have to go through to change your birth certificate.
Right.
And some states don't allow it. I'm glad that don't allow it.
I hear you.
Gender marker.
But nevertheless, you can help us go through that.
Yeah, we'd be happy to research that and try to find out more information and facilitate the process. I just don't know California off the top of my head. Great. Thank you for that information.
Do you want to talk about other segregated facilities? Do you want me to? So the guidance we've been giving you with regard to the restrooms also extends to other types of segregated facilities. And of course, that would include locker rooms, that kind of changing rooms, that kind of place where there might be nudity. What we found in the other jurisdictions as well is the same rule applies, and that is whatever is your gender identity is the locker room by law you are able to use. It's interesting because if you read ENDA, which is the federal law, which hasn't been passed, it's the only place I saw where they talked about a restriction and talked about, kind of a segregated facility. So, we hope that doesn't pass, but all of the 13 states, and we're learning, us too, and the 109 cities say that whatever your gender identity is, that is the facility you use. Certainly an employer or a place of public accommodation can make it more comfortable for everyone involved by allowing, private changing stalls or curtains or things like that. But that company or public accommodation cannot tell you which facility to use, cannot require you to use a separate but equal facility. We're not going back to that
kind of day, right.
And we do expect some pushback in that area. So, be very careful, but you are protected under the law. And if someone says you can't use a certain locker room, you have the right to file a complaint with my office.
So if it's a private organization, if it's like a corporation instead of a public place like a bathroom or a park or whatever, the company is not allowed to discriminate based on them owning the private property in which it's on. For example, like what happened with Cosmopolitan when they had the whole transgender issue that happened there. Then they apologize and whatnot. Because it's private property, they try to make them own laws or whatever. So is that broad reaching?
Yes, because any public facility, even within a private area, and that's why schools are included in a place of public accommodation, like colleges and universities and such. But under public accommodation law, we're talking about public areas, parking lot, restrooms, the ability to go up to the admissions office, that kind of thing. So yes, if you're in a business for whatever purpose, even if it's private, if you're using the public restroom, you're covered under public accommodation law. And then businesses, if you're an employee, of course, you're covered as well from using the restaurant of your gender identity. Are there any other questions on how the law might apply? Yes.
How about if you're working for a company and you're in a facility that's not open to the public and it's employees only? Can they make you use a separate but equal restroom or changing area because it's not public?
Are you meaning you as an employee of that company?
As an employee of the company.
No, they cannot. You are allowed to use the restroom that matches your gender identity. And basically, it's your choice.
Right.
It's not for the employer to decide.
Right. And it's not for them to question you either and say, hey, what's happening with you? Why are you using it? Totally inappropriate. That's harassment.
Okay, I have a question. Just the way I thought the law ran, that was for employers that had 15 or more, so we're saying any size company, 1 to 1 million? Or
No,
is it?
you're correct in that, and thank you for bringing that up. As far as jurisdiction, for employment discrimination law, that company has to have 15 or more employees. And since this is a state law, 15 or more employees in Nevada.
So if there's 10 people, then they can say, yes, you have to use a separate people or whatever, or I don't care if you're identifying as people.
I mean, I hate to say yes, it gives them the right to discriminate, but yes, that the protection under the law does not extend to employers with fewer than 15 employees.
Well, I guess I'm trying to clarify, so don't want anybody to go in and say, hey, and then somebody
That's
else is
correct.
like, oops, sorry, I read the law, you did. So, I just want to make sure that distinction was made clear.
Yes, you're correct in that.
How does that work for children? Like, say, in junior high school, when you sign up for, like, girls' PE or boys' PE and, like, locker rooms, like, do they sign up for, like, if a trans girl, would she sign up for, like, girls' PE and then, like, in the locker room? Like, is it...
From my perspective, we would have to send that complaint to the Department of Education, because schools are kind of tricky, because the programs within the school, the classes offered, those kinds of things are not considered public, so they wouldn't be within public accommodation law. We wouldn't have jurisdiction. So something like that, I wasn't let into a class, or a child not able to go to the PE class and use, that gender facility, we would have to refer to the Department of Education. And frankly, I don't know that they have that kind of coverage.
But let us know if you see a situation like that or aware of a situation like that. It's certainly something we'd want to investigate further.
Yeah, it's certainly something, that ACLU could help you with. My office would just have to refer you on.
I've taught PE in the Clark County School District, and we have had trans men who are as part of the girls' PE class because it's your biological sex, and it's just too uncomfortable for them. And I've even had PE teachers that have removed same-sex couples from the same class because they couldn't handle the lesbian PDA or whatever. So yes, we have serious discrimination in the school district here when it comes to trans rights and same-sex rights. It's
Yeah.
Cool. Let us know, because really that is an important issue.
But then it gets down into how the parents are going to react, and then the parents influence the administration of the school, and then the school administration does whatever to make it, calm, instead of acknowledging the rights and the gender identity of people involved.
Well, that's why we go out and we speak. And if you guys have groups or companies or, community groups where you want me to come speak about this, I'm very, very happy to do that. The more we arm people with information, the more powerful they are. And if it becomes accepted, which of course is the goal in employment and public accommodation, these other arenas, we're hoping there's the trickle-down effect to the classroom and those kinds of things.
Question? How are you guys able to work with the unions?
As far as under employment discrimination law, union is also someone you could file a charge against. For example, if your union refused to represent you because of your gender identity or expression, or any of the other categories protected under the law.
Well, for example, my union won't allow you into their processes because you're not part of their union. They exclude any other entities outside of their union. You're not allowed into their facilities. How do you do that?
That wouldn't be within our purview. It would only be if you are excluded or not represented because of a protected category under the law. Your race, your religion, your sex, national origin, color, age, disability, sexual orientation, or gender identity or expression. So if that's the motivating reason for disparate treatment or lack of representation, we could take that case. If not, our jurisdiction, at least at the Equal Rights Commission, is very narrow. So we couldn't take what you're describing.
So it would have to go to the litigation.
I don't know that it's illegal. I mean, you could certainly speak to an attorney. I'm not sure that that's an illegal process. I don't, do you have any thoughts on that?
Well, again, I think it depends on the motivation behind it. If the situation is one where the union is saying to you, we're not going to allow you to participate in the union, we're not going to allow you to be part of our process based on an unacceptable reason, like gender identity or one of those things, then that is actionable. That is something
Right.
you can complain about with NERC, and let us know too at the ACLU, because we want to know what's happening. It depends I think it would take kind of more of a discussion to understand what the nature of the challenge is. Does that make sense?
It makes sense in that we need more specifics.
Yes, yes.
But what I found with my union, for example, is that if you're not, I'm Plumber Pipers.
Okay.
If you're not a member of Plumber Pipers, you're not allowed in any of their discussions, their legal discussions.
Have you been barred from entering the union of the plumber?
It's not that I've been barred. I've been discriminated.
Right, so maybe you tried?
But there again, I brought it up earlier, the right work state.
Yeah.
And I don't know if you've met anybody in the state of Nevada who have told not necessarily the absolute truth.
That never happens.
Nevada.
I'll say one thing about Nevada being a right-to-work state. Because we're a right-to-work state, you can be discharged without cause. If you look at someone cross-eyed, they can fire you. But it still does not give them the right to discharge you for an illegal reason. So you still cannot be discharged because of your gender identity or expression or any of those other categories. Right-to-work state or not, you're still protected under discrimination law.
So then all we're talking about today is discrimination laws.
Yes, the new laws that took effect for discrimination in employment, housing, and public accommodation. And those took effect October 1st. One thing I've seen in my office is we've received a complaint, but the harm occurred prior to October 1st. It was not, for gender identity or expression, was not protected under the law at that time. So with the new law taking effect October 1st, the harm has to occur October 1st or after. But I will tell you this, if the harm that occurred sounds like it would fit under Title VII, under protection for sex, and from the perspective of sex stereotyping.
Right.
This is how a woman should act, this is how a woman should speak, this is what she should wear and how she should be in the workplace. If it's that kind of issue, we can take that under federal jurisdiction, under Title VII, as a sex-based type of stereotyping. So, don't be discouraged. If you think you've been discriminated against, let us sort through that part of it for you. I think, should we? Yeah. Okay, so we're gonna wrap it up. I just wanted to tell you very briefly about NERC's process. If you need to come down to my office, we take complaints of discrimination in employment, housing, and public accommodation. We have jurisdiction in those areas of law. You have to file a complaint, which starts the clock ticking as far as that 300 days from the time of harm. The complaint for employment is online on our website. If it's a housing or public accommodation complaint, you've got to fill out a paper form. Hopefully soon we'll be able to add that to the internet, but currently you've got to get a paper form. We can mail it to you. You can stop by our office and get one. But as soon as we receive that complaint, then we schedule you for an intake appointment where we sort out what your charge will actually say, what the allegations are that should be included. We offer mediation prior to any kind of investigation or litigation. We do investigation. We issue findings of whether we think there's a violation of law or not. We offer conciliation that we try to settle after the fact if we find a violation of law. And on rare occasions, we can call a public hearing as well. That's also an option within our purview. So that's very briefly like the step-by-step at the Equal Rights Commission. I've got some flyers here and some brochures that have our website, our addresses, our phone numbers and such. I've got some outside as well, if you want that, to get that contact information and some other information that we have. And I'd be happy to talk to you if you just have some questions as well, either after the session or get the phone number off there or stop by the office, and certainly we can talk about this further.
Yeah, our process is in one where we take individual intakes. We have a website, aclunv.org, that has our online complaint form. And you can literally just type in, this is what happened to me, this is what I'm concerned about. We have an intake process. We unfortunately can't take every case that comes across our table. We have limited resources. But to the extent a case raises significant civil liberties issues, that's one that we look at closely because we want to make sure that those things are protected. But we highly encourage folks to send us that information through the website. I also have some hard copy complaint forms if folks are more comfortable with that. And also this is something I think is very handy. I like things in a nutshell, and that's what this is. This is a Know Your Rights card for the transgendered community in a nutshell. It walks through just the very basic provisions of employment protections, public accommodations, housing, and even the process of, say I just want to change my identity on the DMV form, where do I go? It's on here too. So these are available to folks, and please just keep us informed. We want to know what's happening. We can't always take the case, but if we see a pattern and then there are issues, we look at it very closely, and we want to be there to help.
Okay. Thank you very much for coming.